In a major legal victory, the Federal High Court in Lagos has lifted a freezing order placed on the assets of General Hydrocarbons Limited and its directors. The court found that First Bank had misled the court by suppressing key facts, including an existing order from Justice Ambrose Louis Alagoa in a related case. GHL's counsel successfully argued that the freezing order conflicted with Justice Louis Alagoa's earlier ruling. The court ruled that First Bank had deliberately failed to disclose this, resulting in the wrongful freezing of GHL's accounts. The court agreed that First Bank had obtained the injunction through fraudulent misrepresentation, forcing the court to reverse its decision. The ruling clears the way for GHL directors who are now seeking $1 billion each in damages worldwide for defamation and wrongful freezing of their accounts. GHL has also filed a petition for unprofessional conduct with the Legal Practitioners Privileges Committees against First Bank's legal team. All right, Rufai and Dr. Batia, an update on this story. We've been tracking the progress of the story. Recall when it broke, talked about freezing of assets, the conflicts between GHL, First Bank in that loan. What's your take on this update, Rufai? Okay,
so both parties, First Bank and GHL, they have a dispute, a loan dispute. First Bank first went to court, but GHL said that they had a pre-existing, order in court for sort of like a stay on proceedings. But First Bank went to court and they got, some order Mareva to freeze, Mareva injunction to freeze assets, assets across board. So after they got this, the argument GHL made after they went to court to challenge this, was the fact that, to a large extent, that the First Bank did not state initially that there was a prior, court order on ground. So that went back and forth. The case was adjourned. Finally, it's been decided. But here are the words of Justice Dipe Olu. He says, I've carefully read the suits, but the formative part here it says is that it appears to me that the interim order made by Justice Alagoa revolves around arbitration proceedings. So they had a prior arbitration proceeding between the first defendant and the plaintiff in the case, which the arbitration proceeding is pursuant to clause 12 of the agreement between the first and the defendant and the plaintiff on the 29th of May. The position is reflected in all interim orders granted on the 12th of December. Although the interim orders made by this court on the 30th of December are in relation to subsequent facilities agreement between the first and the second defendant, it does not extend to the receivables in the agreement of the 29th of May. And so it's saying that, it now said, if placed side by side, it is not an abuse of process for the reasons given above. However, in view of the orders of Alagoa J made on the 12th of December, the Mareva order granted by this court on the 30th of December is hereby set aside. But also there's a contrarian view to that. First Bank counsel that was reported in another paper was also saying something contrarian, that it was, orders first to 4 that was granted, that other ones, 4, 5, 6, 7, 8, 9 up to 11, was not granted. But, what's it called? GHL had responded to that by saying that unfortunately there have been attempts made on social media to falsify the ruling, mislead public by bringing documents about orders that have not been vacated by the court. The court clearly and unambiguously vacated the entire Mareva, as contrary to what is being circulated. And I'm sure that's in reference to what is being carried, by the Vanguard. So most importantly, these two parties are dispute. Getting settlement has been a touchy issue for both parties, and that's why they've been going at loggerheads. GHL is now saying that they're going to sue in other jurisdictions for $1 billion in defamation. Yeah, probably they're going to make a case, for defamation, and also, for freezing their assets and all of that. So that's this installment in this ongoing case is still quite very fluid. A lot is still going to happen in this case. So definitely we're going to watch it every step of the way.
All right.
Okay, what is the issue right here? On 30th December, Justice Dipe Olu granted an order, a Mareva order, a freezing order. A Mareva injunction is a freezing order. It means that you freeze the assets of the defendant so that those assets will not be disposed pending the termination of the suit. Now, the injunction that he gave was an ex parte injunction. An ex parte injunction means it's only one side that is presenting his case. But because of the urgency of the matter, you then grant the request of that particular party. Now, the other party, under a Mareva injunction, has within 21 days to protest, to file a countersuit and question the freezing order that has been given. Now, that is precisely what General Hydrocarbons has done. So on both sides, both parties have tried to explore opportunities available within the court. The number 2 point I would like to make is that, yes, the public, the media went on a voyage of misrepresentation by saying initially that Mareva injunction means, oh, First Bank will now take over Arise News, First Bank will now take over General Hydrocarbons, will take over these day newspapers. Just pure ignorance. A Mareva injunction does not mean that the owner of those assets has lost his assets. He has the right to go to court to seek for the vacation of the injunction, and if the injunction is not vacated, there will be negotiation. The matter can go to arbitration. So, in other words, again, General Hydrocarbons, the lawyers followed, the right process. Now the court has now looked at the matter again. The major issue here is that First Bank misled the court through fraudulent misrepresentation and concealment of facts. Now, lawyers as officers in the Temple of Justice are not supposed to mislead the court. Lion Wesiel, who is a counsel to Hydrocarbon, General Hydrocarbon, in fact, used the word abuse of court process, because what he was trying to point to his lordship is that Justice Alagoa had already given an order saying that, look, this matter is already in arbitration. There should be a cessation of dispute until, certain other matters come out of this. So they seized on that. And of course, Justice Zipolu had to say, well, you do not have the right to conceal facts from the court or to misrepresent facts, which is a serious matter. Now, when a Mareva injunction is granted, there's a clause there, usually, that the plaintiff will be ready to pay for damages if it comes to light that the other party was unduly brought to court and that person has suffered damages. Again, the counsel to General Hydrocarbons, they have done the right thing by now saying they will sue for damages. So in this case, I think General Hydrocarbons at this moment, emphasize, at this moment has an upper hand because they can sue for damages and go to court and say, well, General Hydrocarbons has suffered this loss of reputation, our directors, stakeholders, they have lost this and that. And that's also why the lawyers, are pursuing that line. However, there's something called res, which is the substantive matter. The substantive matter is yet to be addressed, which is this dispute over $256 million contractual loan agreement. What I suspect is that First Bank is also going to go to court and insist on that rest being settled. So all of this is just about court process. It's just about, rights of the parties involved. But until the final determination of the rest, the matter is not over.
Absolutely. I mean, you've both broken it down and just given the details. We've been following this story quite closely and been, talking about every step of the way, every decision made. And I recall that when the news about the Mareva injunction was broken, especially obtained by First Bank of Nigeria, we'd argued or talked about the merit or lack of it, especially with GHL coming out to say that there was already a subsisting order and that they were going to challenge this in court. So this is no surprise at all. However, what has then happened now, because we're quite restricted in talking about the merit or the details of the case as a result of it being still in court, that what has now happened is that GHL's assertion that they already had an existing order has been proven to be right. However, this is just another episode in what is a continuing series of events. And what a number of people have said, especially legal practitioners who have talked about this dispute of loan, especially in the oil and gas sector, and banks this will set a precedence for that in terms of what would eventually play out in court. And so this is a victory, as it were, for GHL in this first step, or at least just to prove their case. And I recall that even as I'd mentioned earlier, that they'd want to also report the lawyers in question. We've often talked about how sometimes lawyers can try to maneuver their ways across court proceedings and processes, even when they know that the case doesn't have merits, just so that they're able to justify, representing their clients. I think it would be great to also pursue this, just so as to ensure that court processes are not abused. There's no time wasting, especially when lawyers are clear that they do not have any, they don't have that jurisdiction, or do not have that option to pursue the matter in that way. As has been said, we continue to watch very closely as to what will happen. Will the directors go ahead and sue for $1 billion in defamation, especially as a result of the reputational damage that has been suffered? The names have been banded around different media platforms. A lot of people have misinterpreted what the injunction is about and what it can and cannot do. And it would be great to really set the record straight at this point to ensure that people who have worked hard, over the years do not lose reputation or their standing as a result of false information.